Yeah, I'll be there.
Is anybody else calendar full? I open.
I just voted it.
Is the one and fabulous RN that we
that we employ. The rest are from the county. But Kelly, we appreciate you being here and helping introduce this policy for us. So
You're very kind.
take it away.
Good afternoon. I presented to the Safety and Security Committee on February the 27th a presentation that was what naloxone programs look like in schools. It was an FAQ, just brought some information to that committee to take a look at how it's done in other school systems in other parts of the country. After the presentation, Dr. Taylor asked that we take a look at what a policy would look like and come back in April. So we're back in April here at the Policy Committee with that policy. We worked with our attorneys, looked at other school systems policy, the state board's policy, and Dr. Crane's going to help me with walking us through this policy so that she can share with you.
Great. So I want to let you know that in development of the policy, we did learn that the School Board Association very recently, as in within the last 3 weeks, has posted to their policy manual an emergency administration of naloxone policy. Our policy was developed without having looked at that. And basically what we did is our attorney, Patricia Robinson, worked to develop a policy that pretty much mirrors our emergency epinephrine policy. Okay? The big difference is epinephrine devices are required by law to be in our schools, all schools, and naloxone devices are not. So the big differences between these two policies have to do with the legal requirement to be a part of the medical program and choice to be a part of the medical program. So just to walk through the policy briefly so that you know what's in here and what all the paragraphs are. The first paragraph just begins usually with a belief or position statement, so that's there. The second paragraph talks about what the policy addresses, the administration of emergency naloxone under a non-patient specific prescription, so that's what this is about. The third paragraph is the paragraph of the policy that authorizes the superintendent to develop a naloxone program. So that authorization is in that part of the policy. The fourth paragraph talks about this, very similar to the epinephrine devices, how a school identifies who is to be trained, where the devices will be stored, etc. And under a medical care program lists the general statute there, and then provides the only such trained personnel are authorized to administer naloxone, very similar to the epinephrine policy. The next paragraph, the fifth paragraph on the page, is exactly the same as the prior policy about epinephrine. The next one is as well, we don't require that emergency naloxone be available at activities held off school grounds during or after the school day, so like field trips, ball games, etc. And the last paragraph on the first page speaks to this isn't federally required, and we don't guarantee the availability of naloxone on our campuses. The last paragraph on the second page, I think, is sort of boilerplate immunity and civil liability type statement. So this is the policy, and you asked us to bring one for you. We figure you probably have questions about it, and once you've taken a look at this, we can bring it back to you again. We can move forward with it. You can tell Dr. Taylor what you'd like for him to do, and then we can move forward from there. Do you have anything you want to add? Did I miss anything?
I don't think so.
Do you have any questions, comments? Doctor, let's start with you.
Thank you. Just going over it, I mean, it's pretty straightforward for the most part. But my question is, and you probably explained it right off the bat since you said it was kind of templated from another application. But the idea in that paragraph regarding does not require emergency naloxone to be available except as may be required pursuant to an individual student's IEP, Section 504 plan, or health or emergency plan. I don't see where that would apply on some of those things. But, enlighten me if you can.
So the way that I read this, and I may have to ask for the attorney's help, is if we have a student that has a known problem with an overdose, it could be actually part of what a medication that we would keep for that student under a 1702, which is how we store medication for delivery. Much like, I think it's again mirroring the epinephrine. So we have epinephrine for students who need that individually with the 1702, the medication form, and it's stored under their name. But we also have stock epinephrine that is in the school for anyone who does not have their own epinephrine. So I read this, that was put in the state policy perhaps because if there is someone who would like it kept there because their student has a history and would like some kept on site for them particularly. I may be wrong.
I think that's most basically right. I think this is a custom policy that one of my colleagues drafted in consultation with Kelly and her team, and I think the idea was just there's a lot of students out there, a lot of IEPs, a lot of health plans. It's in theory possible that it could be required under students' 504 plan or IHP or IEP that naloxone be stored for overdose purposes or other purposes, and we just wanted to have a catch-all. It's a narrow exception to the general rule that you're not committing to have the naloxone at every school. You would have to if it's legally required by the IEP. That's all.
So, okay.
No, I see kind of where you want to kind of catch everything.
Right, just in case. There may be 0 students. We didn't review, do an audit of the files. There may be no students that have that as an accommodation, but if you ever have one and it's developed pursuant to an IEP or a 504 plan, we just want to have a stipulation that would be required by the plan, not by the policy.
So it's not going to be required to be in a red backpack when someone goes on a field trip or?
Right.
Okay.
Well, again, unless there's a specific provision. I think it's probably unlikely, to be honest. I doubt there's going to be, generally speaking, drug addiction is not a disability that you have to accommodate as a general rule. But again, there being so many students and this being a policy that's going to be in place for years, there could be a unique situation where there is a health plan reviewed by the school nurses, and it's in there, and it's a requirement that we have naloxone for this student, and it could be that it has to travel with the student, perhaps. So
it just seems to me there's a greater problem if we are, that is part of the
right.
IEP.
Right, If the student's addicted to opiates and we're just accommodating that and not addressing the root cause, that would be a problem. So again, I think it's unlikely that you may never see an exception here, but just in case we need it, there is an exception.
Ms. Edmonds and Mr. Hershey?
Yeah, when reviewing this prior to the meeting, the only thing, this is an addition, I think we need to require a minimum of 3 people in the building to be trained on how to use it. And if we only require 1 for our EpiPen usage, then we need to revise that. Because anybody can be away at a conference or sick, and I think it's too big of a risk to have 1 adult in the whole building trained on how to use it. I think we need a minimum of 3.
So the state law says 2 for the EpiPen law. That's actually in statute for that. We don't have any school that just has 1 or 2. So we have multiple people trained because we have 3 people that are trained to give medication to students at every school. Our requirements for that say 2, but we always have 3. So we can change that easily, I would think.
Yeah, because I mean, when you read this, it says 1.
Right.
And I would have no way of knowing that we really do 3. And so why not put it in there if that's our practice?
That's the practice
Yeah.
anyway.
So would you like to match the EpiPen with 2, or did you want to make it 3?
I mean, I'm really more comfortable with 3, to be honest, for both, but
As a follow-up, because what I was going to ask is, what is the training exactly? What constitutes the training for, you can do for both now, for EpiPen and for...
So EpiPen, the training is for symptoms. The school nurses provide that training, and it's actually trained on how to do a partial assessment. That's why there's a training requirement for staff. It's also required to have CPR prior to having that training, which would be the same thing for naloxone. It would be training that would be It shows symptoms of what an overdose looks like. It talks about the administration, how you would administer the naloxone, and then it would have things like calling 911 when it's administered, contacting the parents, those sort of
How
things.
long is that type of training?
I think it's less than like 15 minutes. Like it's
Okay.
and it's a demonstration on how to use it.
So having more than 3 would not place an unreasonable burden likely on staff, given the length of training that it...
No, because with our EpiPens, we have multiple people trained in the school setting to give it to individuals, and we have multiple people trained to give the stock epinephrine in the school setting.
So I'm happy to support, I definitely think we should have the more the merrier, trained on all fronts. But I just also want to say thank you for having this policy. Thank you, Dr. Taylor, for asking them to bring this. Thank you to our policy chair for having this on there. And I'm going to take the moment to just say that I hope, since it's budget season and we're having a new policy put in place, that we will consider having the funding in place as a backstop. I know staff is going to look at alternative places to find funding for this. But as we're creating a new policy, I think it would be a great message to our community that we're going to ensure that it's there, and it's, you know, a maximum of about $30,000 to $35,000. So I just wanted to say that while we're talking about this policy. But this is fantastic. This warms my heart that we're going in this direction. I think it's crucial, and at some point it's going to hit, and we just got to be as ready as we can be.
Hope we never need it.
That's the truth.
Ms. Ray? I just wanted to add data to why this is important. As you guys know, I'm a mental health first aid trainer, and part of the training within mental health first aid is knowing how to distribute the Naloxone and medicines. But the DEA in 2020 recovered about $5 million, about 5 million pills, prescription pills on the street. 2 of every 5 were fatal. And that's the perks that the students are using, and it's the fake prescription pills that are in that have cocaine and fentanyl in it. And many may know that's how my son died. And so it's a real thing out here for youth that are young with those age ranges. My son was 25, but and he didn't know he was taking a fake pill because he was not well at the time and at work. But the fact of the matter is, sometimes students will take a pill that they think is okay from someone else, and it's really not. And just thinking about that number, 2 of every 5 are fatal. So, thank you guys.
Thank you for bringing that, and I do think that it's important, especially in this day and age. We do hear a lot of these stories, and speaking on behalf of what you just said, that actually happened in my community weeks ago. To 3 boys, or 2 boys took it, and it really hits home when you hear these stories over and over again, that nobody's safe from it, no matter where you are. But maybe it hasn't hit in our schools yet, but better to be safe than sorry. So, I mean, I absolutely agree. I don't even think 3 is a small ask. I think as many people that want to sign up, maybe even just have a staff day that, and did you say it's 15 minutes or 50?
It should be 15 to 20 minutes, I would say.
So
most of the
15 to
trainings.
20 minutes to train staff. I would say a dozen people in the school. I mean, you have people, if you think about the size of some of our hallways in schools, you may not even have those 3 people that are trained in that wing or near or off. They might be outside with the class, and
So I was thinking of the purposes of policy, what
Right.
number to put in here, and I appreciate, we may do way more in practice, but no parent or member of the public is going to know that if we don't have some kind of larger minimum written in policy. So that, yeah.
And then the second half of that, I was going to ask, what would it look like if we were to use this as part of our campaign to get education out to not only staff, but to parents and other children? I mean, teenagers in high school may see this happening and not be able to reach somebody, you know, if they're off on the field or something like that, or in the parking lot and they see this. If they're all just trained how to use it and we get that education out there, you know, like a small video education type of thing that we blast out to families. And I'm a firm believer in knowledge is power, and the more that you know, there's no harm in knowing. So I wonder if that couldn't be part of, you know, our communications blast. Thank you.
I mean, sadly, this is something that more and more folks are feeling it in their personal lives, whether it's up close and personal or within the community. Are there other questions or comments, Dr. Ng?
Yeah, I agree with that idea of just kind of using this as an opportunity to educate the community, the students, the parents. You know, just like in, you know, the campaign to help people recognize the symptoms of stroke. You know, there's an acronym, you know, that people remember, and so that way people easily can recognize the symptoms, even though they may not know what to do about it, but they can call 911. You know, and even if the Narcan is not available where they are, they can definitely call to get help. So I think something to consider for our system.
Yeah, and even if that's something that Wake County government or DHHS or a federal agency has information for, because we don't have to ask Kelly to reinvent the wheel if it's already there.
Right.
Mr. Haggerty and Dr. Taylor?
Just building on that, we have a line in here. Each principal in collaboration, principals are encouraged to include in the plan school-wide employee training and recognizing symptoms of opioid abuse. You know, do we have to limit it at, you know, school-wide employee training as opposed to just school-wide training for students or families? If there is, to your point, like a sheet or an acronym that could go home with parents, or that, you know, could be used in schools as part of their other safety training, even if it's just something that goes out once a year, just something so that if something happens in front of a student or a parent sees, if we help them
They can get an
recognize.
adult.
Yeah, and it just, because we're already encouraging it, we're not laying out what it has to be, but we're saying that you should have this training and recognizing the symptoms as part of the plan. You know, we just change one or two words and expand that scope.
I'm going to call Dr.
Yeah,
Taylor
sure.
and then I'll come back.
Just very quickly, thank you, Madam Chair. So we will make sure that we identify the proper training pieces that we need to put in to address this. But I also wanted to say that I had an opportunity to meet with the new health director about a month ago. And so they are ready and willing to partner to make sure that we have Naloxone on hand. And so I know there were some concerns about the cost. And so I don't want to get too far ahead of the whole train, but I think the partnership that we have with them will more than support us in the way that we need, and it won't be a financial burden. But once we work out the particulars with that, I'll certainly share that with the board. But I thought that was good news to hear.
My question, and this would be maybe for staff to bring back to us as we talk about how many in each school. If the numbers, and I would assume that they are skewed at the high school level, do we have the policy in a way that really all high school staff should be taking the 15-minute training, and maybe you limit it, it's significantly less likely in middle school, or I'm sorry, in elementary school, because I feel like that would be where the real risk is middle and high school. I don't want to place a lot of extra burden on, but 15 minutes, as this as widespread as it is, and it will continue to be in this country and the world. Just a thought for the board.
Well, and my question on that is, when we have, or when we have like a sporting event, like when you go to a high school football game, there are a ton of people there. So making sure, you know, our athletic trainers and ADs and maybe our coaches are given the opportunity to get that training. Just because you're dealing with spectators and a bunch of folks. So I don't want to change the policy, but I
Right.
think as we go and look into putting it into practice, those are,
Sounds good.
all right. Anything else before we go forward? I think we just have the one change of one or more to three or more.
3 or more, I had noted that. And I just had one general question. I don't know if this came up, and I apologize for being late. but
Ms.
the-
Rice, I'm sorry, I forgot we were going back to you. It's okay.
Oh, I'm sorry, was there another?
No, I messed up on my order, I'm sorry. I had Ms. Rice down as having a comment, and I forgot. It's okay.
Am I interrupting?
It's all me.
Okay. Well, I just a question for the policy committee. You know, we have the custom drafted policy, which I think is in many ways more specific and detailed than the NCSBA one. The NCSBA one came out in an initial release after we'd already drafted this. Just a question for you, do you want us to try to align these, or do you have a preference for one over the other, or should we just stick with the local policy that we crafted specifically for you? It's up to you all.
Don't think on it. Let's let Ms. Rice weigh in, because I feel bad that I'm not.
Oh, no. So I was wanting to, we were talking about the training in reference to delivering the medication, but also I think what's equally important is understanding the signs and symptoms of what that might look like to even know that you need to administer the medicine. And so I'm hoping that at some point we may even be able to bring in our student services team that's doing an amazing job right now with sharing the mental health first aid piece for youth and their training. And I just want to encourage us to, while the funding is currently free, to make sure we can train as many staff as we can while the funding is still free. I know that they're doing a great job, but I think we should expand it as best we can, even to, because we talked about community and stuff like that, or maybe families with, you know, in special educations or whatever the case might be, that are interested in it, if we're able to do that while funding is still available until it ends. So
I think I heard that, but I'm seeing Dr. Tyler nod his head, so I'm assuming that's a yes, we're going to get the information out there. Okay.
Just a response to Sam, Mr. Hershey.
Sam.
I feel like all the schools should be trained, because I mean, this is affecting adults as well, and so other adults need to know, recognize signs, symptoms in the other adults, even if it's the children are not the ones to take it. And then your point is that, you know, it could be inadvertent consumption of something that is laced with it that there was no intention of taking. So it's important that everybody be aware of the signs and symptoms.
So, Neil, I don't think that answers your question, but I think, you know, for me, I appreciate this policy and that it hugs a policy that our staff is already familiar with
Yep.
the epinephrine policy.
Yep.
So I
I
don't
mean,
know.
it was designed for your district in consultation with your staff, so I'm very comfortable with it, just throwing that out there for you.
Yeah, I don't see the NCSBA copy anywhere, but I'm comfortable with this one.
I did not include it.
Oh, it wasn't- I'm sorry.
I didn't include it. I did share it prior with staff, but did not include it for you guys.
Honestly, I looked at it when they released it. It's less detailed. It doesn't have anything that you don't have. It's got less detail.
Right.
Essentially, it's got
I'm
structure.
good with this one,
Yeah.
too.
Sounds like all of us want more direction rather than less.
So you can stick with the current.
Is there a motion to send this to
So moved.
Second.
first reading? All right, I've got a motion from Mr. Hersey, a second from Chair Haggerty. All in favor, please say aye.
Aye.
Any opposed, nay? All right. Thank you so much. Thank you, Ms. Creech, for your work on this.
Thank you.
All right. We're going to move on to the personnel portion of the evening. And again, these are all a part of the migration again. We've got Ms. Hill, Ms. Petoskey, and Dr. Mutillo, and I apologize if I mispronounced that, Sally. Please correct me if I mispronounced your last name. Okay.
It was exactly right. Thank you.
All right. Ms. Hill, you get settled in because we've got a few of these, and whenever you're ready to start.
I'm raise the seat a little bit. All right. Thank you. Good afternoon, everyone. We are here to continue our journey in employee leave policies. We wanted to start with one that we had brought previously, which is policy 7516. That was our civic responsibility leave policy. And the board reviewed this policy in March of 2024. And as you may recall, it deals with community function leave, volunteer service leave, jury duty, court attendance, leave for all those situations. One of the issues that came up previously was about the guardian ad litem program and how this leave may impact that program. So we were able to get some research done and had some outreach to that program. And what we learned was that in general, the guardian ad litem volunteers aren't usually compelled to be in court or to meet with children or support personnel at a particular time. However, they do issue subpoenas for teachers who are serving as GAL volunteers to come into court so that they can be excused by work. So what that does is pull that under our court attendance leave, which helps with that. They also informed us that they do allow for virtual testimony as need be as well, and sometimes just a printed report rather than an in-person testimony. Our understanding is that volunteers are requested to appear in court 3 to 4 times a school year, and that if our teachers need to, they can work with the guardian ad litem attorney to get a subpoena in order to appear in court. Other trainings, meetings, those sorts of things can be done working outside of the regular work schedule. In looking at that, one more thing, for non-teacher volunteers, they generally don't receive a subpoena according to the information that we have, but could request if they wanted to seek to request or work around that time if need be. Based on that information, it looks like, as I said, court appearance for teachers will be accompanied by subpoenas, that there's flexibility in presenting information to the court and other meetings occurring outside the workday. And so we feel like the policy does allow for and protect those times, and that we don't need a separate carve-out for our teachers who may be participating in the guardian ad litem program. And with that, just to go back into the policy as we were looking previously, we are recommending this policy. We did make some modifications to the policy, again, based on discussion and just making sure that we are clear about some of the processes and programs in here. As we said before, if this policy is adopted, it will replace section 7.1 and 7.3 of our current policy 2280, 3800, 4800, which is our current leave policy. The change that you see in your manual or in your documents includes information that we had previously presented to you, and then a modification of that information to try to more clearly specify what we mean by volunteer service organization and who participates and participation in those volunteer service organizations. This is in section A2 of the policy under purposes. It makes it clear, as we discussed before, that volunteer activities would include volunteer activities for the school system, for a Wake County local government agency, for a state government agency, or a state-created entity. And the state-created entity we specifically pulled to get to the guardian ad litem issue because that program is a state-created program, or a volunteer service organization in Wake County. And we then laid out a modified definition of a volunteer service organization so that we could make sure that we are taking into account a lot of the changes in some of the legal language about, for example, faith-based organizations and those different types of organizations. So we have added a new definition of volunteer service organization, which means a nonprofit, nonpartisan community organization in Wake County that's designated as a 501c3 civic, charitable, or humanitarian agency, or is a human services organization licensed or accredited by the state to serve citizens with special needs like children, youth, or the elderly. Right now, the language that we have in here says by the state in which it is located, but we'd like to change that to just say the state of North Carolina, because that pretty much gets to us. Also, this type of organization would be like a nursing home, for example, a place that won't fall under your 501c3s, but is a humanitarian or human services type organization that would be covered here. So we would like to request this modification with marking out the words by the state, in which it is located, and changing that to by the state of North Carolina, and where the human services organization begins, if we can put the word is a human services organization, so we can make it clear that some are IRS code or organization, 501c3, others are human services organization. So requesting a slight modification to the information that you have there. But again, we believe that this new definition, or this updated definition of volunteer service organization, really helps our employees understand the types of entities we're talking about. It helps our community by, again, expanding those type of entities that we would cover for employees to volunteer their time at.
Appreciate these changes and specifically addressing the guardian ad litem program. And we'll open it up for comments, questions, concerns. Ms. Caulfield, we'll start with you since you were a passionate advocate for guardian ad litems.
Thank you, and I appreciate you bringing that and kind of separating it out so it makes it a little bit more clear. I just have a question. One of the original things that I was concerned about when it was kind of more lumped together was the amount of days. Mm-hmm. I don't see that here, so am I interpreting that right, that they're not limiting the amount of days that they can do it?
So this still, if you look at the eligibility, it still talks about, so let me step back for a moment. Are you specifically talking guardian ad litem and with regard to that, or in general?
I am, but I was confused when you were talking if we were starting with 7514.
No, 7516.
Yeah,
I'm
okay.
sorry.
I just want to make sure, but yes, so I am in the right spot then.
Yes.
In regards to that, yes.
Okay, so first, just in terms of Section A here that talks about community responsibility, you'll see there's a section on Wake County volunteer activities. In that section, we talk about 2 days of volunteer leave, which is consistent with what we had before. One of the things in looking at the guardian ad litem program, and I think the question of whether we needed to expand those number of days because of the needs of the guardian ad litem program, our research showed that, in fact, the folks who are participating in the guardian ad litem program may be subpoenaed, which then takes us to Section C of this policy, which is the court attendance section. And so they would not have to use volunteer days to do that. They would be able.
There's no limit on the court attendance.
There's no limit on the number of court attendance. If you're subpoenaed, you would just attend based upon that subpoena. So we felt like with understanding that our teachers could be subpoenaed, that pulled them under the court attendance, which didn't have a limitation. And then to the extent that they still want to use volunteer days, and it's not a student in-person day, they can use those volunteer days as well, just like any other employee could use those 2 volunteer days. So we did not recommend increasing those volunteer days because there was sufficient information or sufficient opportunity for teachers to be in court to address their guardian ad litem program through the subpoena process, which does not have a limit to those number of days.
Okay.
Thank you for that.
Does that answer your question?
Yes. And now with the policy manual, if they search guardian ad litem, this court attendance part will pop up so that they can read that specifically?
Right, because we specifically included that as an example in here. So such as an eyewitness to a crime or to appear as a guardian ad litem. Those are different official duty type of circumstances.
Ms. Edmonds?
Yeah, I just wanted to echo the thanks for doing all that homework for us and research for us. It's much appreciated. And when the time is right, I would like to move that we move 75, 14, 15, and 16 to, are we back at first reading, starting over?
Yes.
Okay.
We haven't gotten to first reading yet, so we would be moving forward.
So moved. Did you make the motion?
No, but when appropriate.
Well, we'll call that a motion. And
Okay.
we can call Ms. Edmonds, and we'll call Mr.
Second.
Hershey's a second, and I'll say, are there any other questions, comments, or concerns, Mr. Haggerty and Ms. Rice?
Okay, thank you. I'm trying to go back and just understand the definitions again. We know what a 501c3 nonprofit is because that's defined by the IRS tax code. For purposes of definition, humanitarian agency, what exactly is, can you tell me again what that is?
So that's all a part of the dedicated as the IRS code as a civic, charitable, or humanitarian agency. So that's all a part of that 501c3 portion. The portion that is different is the human services organization,
Okay.
licensed or accredited by the state to serve citizens with special needs like children, youth, or the elderly.
So where would one go to find a list if it says it's accredited by the state, right? So I know that I can go to the Secretary of State's office and I can get a listing of nonprofit organizations, but we've already defined nonprofit organizations, right? So, what defines, like, I guess, so you mentioned like the care homes, they have a license, right? But then the accredited, I'm just trying to make sure I understand everything that's covered by this.
So, again, this is specific to entities that would be serving children, youth, and the elderly, or including children, youth, and the elderly. So it really would depend upon the person and the nature of the entity that they are seeking to serve with. And I'm not even going to pretend that I can...
Volunteering at Tammy Lynn Center, for example, potentially?
Correct.
I'm saying that because I know somebody who has an in there with maybe they're accredited or licensed, I don't know. I'm seeing a head nod, so.
Not sure of that.
No, it's not you, don't worry.
Okay.
Okay. Volunteer at a daycare.
I don't want to put anybody on the spot.
Sorry, yes. So we don't have a specific limit to those, but recognizing that those sorts of organizations that would, that serve those groups normally would be licensed, or at least we're saying we want them to be in order to use that for volunteer purposes.
Okay.
I think you find the licensing list based upon the type of entity you're serving.
Yeah, because I know that a lot of these are going to be a different tax status than a 501c3, and was just trying to figure out, like the Guardian Ad Litem program itself. I don't know enough about it. I mean, is it administered by the government? Is it administered by the local bar association, or is it its own?
Well, again, Guardian Ad Litem, this is why we specifically included before the volunteer service information, we included state-created entity, because they are, in fact, a state-created entity.
By statute.
And I can't remember if it's by statute, but do you recall? I can't remember. Okay. So we try to capture as much as we could, but still give some guidance, so it's not a free-for-all for any type of entity. But with regard to this specific one, the human service organizations, again, it would be based upon your interest, and then we would look to see, or the employee could provide information to show that that was a licensed entity in the
So
state.
long as they met that criteria, it would satisfy it. Okay, thanks.
So I'm walking along the same lines as Chris to a degree. Mr. Haggerty to a degree. We're saying, because I'm looking through an equitable lens, because there are a lot of great organizations that are doing the work and maybe have not received their 501c3 license, but they do have they are established as a state nonprofit until they get their, because some people may not need a tax write-off to do what they're doing, but they're doing nonprofit work as licensed by the state in order to even receive a bank account to do so.
It's a social enterprise.
Right, and so it's like, with this, depending on what supervisor chooses to give, and I don't like that language either, to give permission for people to take off, how are we addressing that? Are we only making it that they have to be a 501c3 organization?
So I want to, that's a great question. I want to just kind of step back to where we're coming from, because this is a broadening of where we've been. Previously, all that was permitted was a 501c3 entity, the end. So we've already done a huge expansion with the information here. Bringing in volunteering in the school system seems like it's something that would quickly make sense, but that was not a part of our policy before. Looking at state agencies and local government agencies, again, an expansion of our prior policy. These strict state-created entities, expansion of prior policy. 501c3, back to what we previously had in prior policy, and then pulling in the human services organizations. And if I'm recalling correctly, I think the human services language is something that comes out of state policy, I believe in the state personnel manual, if I recall correctly. So we are doing a significant expansion of the types of entities that we're talking about here. Does that mean we may miss some? Yes, perhaps, but I believe that we're giving our employees a great opportunity to find entities that fall into these broad categories to be able to spend their time volunteering. So I'm not sure there's a way for us to write the policy to hit everything, to make sure that, there is some guidance to our employees about the types of entities that we are, that are approved for this. But I do think we've done a lot to expand those entities.
Thank you for that.
Thank you. So, and just to be clear, and understanding that the intent is to expand upon it, right? To expand what's currently offered. There's language here in the strikeout specifically talking about faith-based organizations. And so could you just address that a little bit in terms of, before it was saying it could be for a faith-based organization if it was specifically for a secular purpose. That would seem to be included under the new broader definition too, but because this is specifically struck, are there similar restrictions for the purpose, or does this create any confusion about faith-based organizations, or what do you?
We believe that by striking that language, we more align with some of the current standards that our courts have been putting forth. So we're not limiting our employees in terms of what they're doing as long as it falls in here. We no longer have that specific language about if it's a faith-based organization, it has to be a secular type of activity.
And that secular purpose restriction was struck by recent Supreme Court cases?
Correct. I was just going to say,
Right.
we researched this issue. That test has been overturned by the U.S. Supreme Court. So we think the policy was a valid rule up until 3 years ago.
Okay.
And now the Supreme Court says that's not the rule. So I think your best bet is to have a religion-neutral policy. This faith-based organizations aren't excluded. You have defined the purposes for which the league can be used, but it does not matter. No one's treated differently or analyzed differently if they're a faith-based organization or not. If you're a 501c3 or if you're accredited by the state to pursue one of these functions, you're eligible for that leave.
Sounds like you found a way to expand it, but also provide some guardrails, so if a principal is going to approve the leave, they can look something up, make sure that it's there, and, make the approval in a more quick, expedient manner, rather than asking the employee that's just looking to volunteer their time in the community and, ask a ton of questions.
And as always, we are always available, and we do now, to provide guidance in those situations. We get those questions and we respond to those questions of whether, is this, I've spent time researching 501c3s to see if an entity is or is not. And so we remain available to assist our schools with that and assist our employees. But we feel really positive about these changes and broadening it and giving some more guidance and direction to our employees about more ways that they can use volunteer leave.
Neil, is our motion and second still valid?
There's a motion and second, and this is discussion, so you can call for a vote whenever.
Is there any other questions or comments? All right. All in favor of moving this to first reading, please say aye. Aye. Any opposed, nay? All right, next up on my list is 7514, educational leave.
Yes.
I actually thought the motion was for all three policies to go to.
For all three, I'm sorry.
Because I felt like we
We got this, sorry. All three policies.
We can-
So, sorry.
Still may have more to say.
14 and 16, moving on to, where are we
Sorry.
going here? No?
Not yet for you.
Not yet. Okay.
I appreciate the
Set me straight, Ms. Hill.
I just wanted to, because I don't think we had previously gone through actually 75, 14, and 15.
No, I didn't think so. That's why I thought they were separate.
And a lot of what's in, starting with 7514, a lot of what's in here is us laying out some of the information from the BPI manual to make some clarifications for our employees. But one of the things we did in working with 7514 and 7515 is to create clarification around use of education leave versus professional leave, because there has been some confusion about it. In sending you the information for this meeting, I actually created some confusion myself because I sent you the wrong version of 7515, and we have that to give you in just a moment. Well, go ahead, Sally, because this will help you see how we've tried to put clarification in between these two types of leaves. When you see 7515, we are now calling it professional organization leave, to make it clear the type of situations that are covered by that policy. So passing that out to you, and I apologize for that error in sending you the wrong policy, and just realized that today as we were coming over, so I couldn't even send it to Dr. Crane to update that information for you.
And we will get that updated in assembly proactively.
Absolutely, thank
All
you.
right.
So with 7514, 7514, we'll start with that one. I gave you a copy of 7515 just so you can understand we are trying to make distinctions between these two types of leave. So with 7514, we are looking at education leave. And this is basically when people are going to trainings, when people are going to workshops. One of the things that we did here is add section A on applicability to make sure our employees understand that if they have approval to attend a workshop or come to central offices for a training or whatever, they don't have to take leave for that. We permit employees to do so when they need substitutes, because the substitutes are often connected to the leave, and so we clarify that in here. But we also just make this statement clear. If you're going to a training at central office, you don't have to put in for education leave. It's just a different place that your work assignment is happening for the day. If you're going to a training at the McKimmon Center, that your boss says or gives it okay for you to go to that training for the purposes of increasing your knowledge for the school system, that's where your workspace is for the day. So we're trying to limit those situations where people are having to fill out leave forms unnecessarily, and make it clear that's you doing your work for the day. there are situations where people may need to use education leave, and we've made it clear what those situations are, who those employees are that are eligible for that. If, for example, again, a lot of situations where teachers may need to go to a training because they need to have substitutes, that leave often triggers how that substitute is paid and what those processes are. So our purposes here were to try to clarify that for our employees, make sure they understand when they need to use leave, and then when that happens, if it's an in-service school project or a school system training, it has to be approved. That's still in here. And sub-pay will follow the rules that we have laid out here with regard to substitute pay. If it's a state-sponsored staff development activity, again, the substitutes are going to be paid based upon appropriate state budgeted funds. And then this is consistent with the DPI manual about the Center for Advancement for Teaching and how that's paid for. And then Section F in the policy really breaks out two sections. One is you may have a situation where you're using unpaid education leave. So if I'm an employee and it's not something that my supervisor says it's great for me to go on, but I feel like it might be something that helps expand my knowledge in some way. Sally and I have come up with some theories or some places or some types of things. It may not be directly related to my work. If I have my own personal leave, I may be able to use my own personal leave to do that. If not, I may use unpaid education leave. And the reason why we put that in there is because non-paid leave may trigger excessive absences concerns. It can be something that creates concern if the employee has a lot of non-paid leave beyond their leave balances. But unpaid educational leave would then indicate this isn't somebody who's just out of work and doing nothing and taking non-paid leave because they've run out of leave and they're just doing whatever. This is somebody going for an educational purpose, but their supervisor hasn't said it's truly for work educational purposes. So we have that in here. The other place that we have in unpaid education leave comes right out of our policy on 3800, which is for people who are taking leaves of absences to pursue educational credentials. And so that process is laid out in here, again, following what we have in our policy right now with regard to that. So that's it on education leave.
All right.
I'll take any questions.
So we had a motion and a second and most of the votes, but I think since there's an
Yeah.
updated
No,
version of this
and-
policy, we need to
And that's on me.
redo.
I thought that was just for the
Yeah.
6 months ability. So we got ahead of ourselves. We got a little eager. So if we're able to consider it just for that, and then unless we need to do these as a package, Neil.
I mean, you can
Ms.
vote on them
Edmonds
separately or together.
said that she will withdraw her motion.
That's,
so
if you didn't collect all the votes, I heard some
Yeah.
votes, but I think there might have been some
Let's go
sidebars.
with the
We'll consider
withdraw
that
and we'll do it all.
an incomplete
Yes.
vote and
Okay.
have a do-over.
Sorry about that.
I'll do that.
And I want to explain why, but I'll wait till
All
it's
right.
my turn.
Well, it is your turn, Ms. Edmonds. Go ahead.
So I recalled from our work session, or excuse me, our meeting last week, that we had done a blanket of policies on leave. I'm looking at them right now, and I thought these were those. So I thought I thought they were coming back for some reason, but now I'm looking at last week's agenda, so
Thank you.
that's why I was saying, well, let's just move along.
Well, we know that we're putting a lot of them in front of you, so
Yeah.
an easy mistake. As a matter of fact, I literally pull out a paper each time to figure out which one we're on because
No, when I was reading the materials before getting here today, I was like, we've already done this. Oh, okay, they're coming back for some reason. No problem. Anyway, but that's where that came from. So let's just start again.
They had pulled these because we had questions, so they said these will come back later, but the other ones went ahead. Yeah.
and I did want to add that once this policy is adopted, it would replace section 6.1 of our current policy.
Any other comments on the educational leave? Mr. Haggerty?
I just want to make sure I understand, when we're talking about professional responsibilities, we've talked a lot about training, but wouldn't this be, like, for example, there's a North Carolina Environmental Education Office, right? And they'll have teachers and others that'll set up conferences on environmental education. is this leave for attending the conference, or is this if you're an officer of the conference, that you could go and help to plan and set up that meeting?
It's like you set this up for me to answer. This would be for attending the conference. 7515 would be for being an officer or
Okay.
a member of the organization.
That's the professional organization leave?
Yes.
Okay, I've got you.
Thank you, Mr. Henry.
Well, unless there
Perfect
are any
example.
other
Perfect.
questions or comments, I think we can segue right into 7515.
Yes.
We good? All right, let's do it.
So, as Mr. Haggerty pointed out, 7515, if you see the substitute version that we provide to you, we have tried to make it clear that this is for professional organization leave, separate from the training. And we've included language in here. This is again, a new policy, just like the last one was. This is an added policy that we're doing from our own manual, not a School Boards Association policy. The strikeouts we're showing here are the changes between what I sent you and what this should be. So I sent the wrong version. But again, calling it professional organization leave, and then clarifying in here that this is dealing with duties related to professional association boards, commissions, organizations, those sorts of things. And the section of the DPI policy manual that deals with this has very specific organizations and information about granting leave without deduction for particular organizations like the State Board, the State Textbook Commission, Board of Governors, and then other professional organizations where someone may be an officer of those organizations. So this is to, again, we're trying really hard to clarify for our employees, here's where when you're getting the training, here's where when you're part of the organization and you're taking leave related to your duties in the organization.
Does that answer your question, Mr. Haggerty?
Yes, it does.
All right.
So does this mean for 1715, it needs to say, does it have to say professional organizational leave? Is that what you're saying?
No, it just, I was looking at what would fall under one policy and what would fall under the other, and Ms. Hill
But
explained it
14
to me.
is professional leave.
14 is education leave.
Educational. So,
Yeah.
so,
And so this, I asked it under 14
Yeah.
to distinguish what 14 and 15 were.
okay, I see what.
Yeah, I just got ahead of
You got ahead of me.
I feel like I
Yeah.
got us all off track. I'm sorry.
I got it now.
Yeah.
I will clarify or add that this would replace section 6.2 in our current policy manual.
So are there any, and I appreciate you adding the professional organization leave, because professional leave and education leave almost seems like they're
Right,
the same thing.
It has confused me for years, and
Well, and now you get to fix it.
One of our most frequently asked questions around here, so we're all excited to clarify this for our employees.
Well, all right.
our goal is to help make things easier and better as we go through this policy migration.
So then do we need a new motion for all three, or do we want to just go for all five?
Either way, now that we've walked through them all, I think you're poised and ready for one motion on all
All
three if you'd
right.
like to.
Ms. Edmonds,
Up to you.
get up again.
Okay. I move that we, so are we doing family and medical and military, even though
We're
we
not
haven't
including-
discussed?
We're not
Just
including
the-
those.
Yeah, we said five.
I appreciate
So
it.
75.
No. Just don't listen to me.
14, 15, 16.
14, 15,
All right.
16.
The motion is that we move policies 7514, 7515, 7516 to first reading.
Second.
All right, motion from Ms. Edmonds, second by Mr. Hershey, and this is only on 7514, 7515, and 7516. Are there any questions about this motion? Okay, good, we're all clear. All in favor, please say aye.
Aye.
Any opposed, nay? All right. Now, on to the new ones.
And just for clarification, we will include the two changes in 7516. Yes.
Thank you.
Okay, on to 7520. Dr. Ng has been asking us about the family medical leave policy, and we have it, and it's a 12-page policy, I believe. This is a policy that is in the current School Boards Association manual, and we have added to this policy some of the modifications that we pull in some of our language or information from our existing policy. This is a very thorough policy that provides a lot of detail and information to our employees so that they can understand the family medical leave process. It starts with the definition section. So just in the introductory section, we just made it clear that the policy is going to be provided to employees through the handbook or to other materials that we have that talk about leave and benefits. We go into the definition section of serious health condition, making sure employees understand the types of situations that FMLA applies to. We also added in a phrase from our existing manual that an employee's workers' comp absence may qualify for FMLA if it meets a serious health condition. In section A3, we added the definition of family member here because it is a different definition than than the definition used in most leave policies. This definition is set by federal law, and so we wanted our employees to know, see, clearly understand that this is a separate definition for family member with regard to Family Medical Leave Act. In section B, we just clarified for our employees. This section shows what the eligibility is, hours that need to be worked, the time that you have to work for the system, and then we let employees know that they'll look to section D to talk about where the 12-month period for FMLA, or what that 12-month period is. The next section just talks about the sorts of conditions that would qualify for FMLA. Section D talks about determining the 12-month leave period and the 12-week entitlement period. And for our purposes, we use a 12-month period that is based upon when the qualifying FMLA event occurred. Federal law allows you to use different ways for calculating the 12-month period. It can be based on a calendar year or other types of ways. We use it based upon when you had that FMLA event, and then it's 12 months from there before your time period. We also include in here just some information about the 12-week leave entitlement, including how holidays are treated and what happens for 10 and 11-month employees.
So Ms. Hill, for example, if someone has a baby on January 1, does spring break is a part of the FMLA weeks, or is it separate from the FMLA weeks?
So the FMLA talks about holidays that are broken out. If a holiday occurs during a week that somebody already has FMLA leave, or you're taking that whole week, then that holiday is going to count towards your FMLA balance, your number of days. That's not something that we came up with.
No, I know. It's been 9 years since I had to think about this policy, so I'm trying to remember.
It's very interesting because pulling in the holiday information and making sure we lay that out for employees, that wasn't in there before. We pulled it from the DPI manual, which pulls it from the federal regs, and it's an interesting provision, in my opinion, not as employee-friendly as it could be. Because you remove somebody's leave even on a week where they might not have been working otherwise. However, federal law makes it very clear that that's the standard there for that. If it's a partial week that you would be taking, then, and a holiday comes up in that week, then it doesn't count towards your FMLA balance. So it's again, just straight from the regulations.
Yeah. Mr. Haggerty?
So, just to follow up on that, so if I read this right, you don't get credit for spring break, but if you were a 10 or 11th month employee, you would get credit for the time in the summer when you were off. If you were on a traditional calendar, the baby comes June 15th, right? It doesn't start up until what would have been your first day of school in the traditional calendar. So for employees in year-round schools, those track-out periods are considered what?
So for employees, 10 and 11-month employees, and their track-out periods in summers don't count against them unless they were supposed to be working that time anyway. Because we do have some who may have a time period during that where they're supposed to be working, an 11-month employee who's supposed to be working during the summer, it would not count against them unless they were supposed to be working that time.
It's all based on that, if they were required to report?
Mm-hmm.
Okay, thank you.
Am I correct in recalling that those are DPI rules?
Yes.
So that section that you're asking about, these are all, it's pretty much straight out of the DPI.
It's straight out of DPI, and then, so I know with the Section A, it's straight from the federal as
reg.
well. Mhm.
It's probably 95% of the policy straight out of DPI manual or the federal regs.
Yeah. And even though there are clarifications, I'm sure you're going to continue to get the questions because I'm seeing other hands up, and I apologize for, but Ms.
FMLA
Edmonds and
is-
Dr. Ng.
It's very interesting, and it's
all
expensive,
federal.
And it's all federal mostly.
Thank you. Section A, number 3, the definition of family member, is it federal mandated that we define a partner as joined in a marriage recognized by state law? There's a lot of people that are together for a long time that choose not to be married.
I believe spouse is the language that's in the federal information. I don't have the federal regs with me.
Yeah, I want
Let me
to
check it.
I want an answer to that before I can support this, because there's no need, unless it's a federal requirement that that's how it's phrased, we should recognize people's partners that they define as a spouse, even if they're not in a marriage recognized by the state.
Understood.
I'm with you, and I'm going to assume that it's federal, but I think it's.
Yeah.
And if it
I've
is,
got the
that's-
definition.
If it
Yeah.
is, that's the
Neil's
answer.
got it.
Okay.
Yeah, and the federal definition, spouse means a husband or wife. For purposes of this definition, husband or wife refers to the other person with whom an individual entered into marriage as defined or recognized under state law for purposes of marriage in the state in which the marriage was entered into.
So our hands are tied on that
It's
one.
a federal rule. Yep.
Can we
We
cite
did
that?
use partner.
Oh, I know. But I mean,
I know what you're saying.
my own mother-in-law has been with someone for more than 30 years, and they're not married. You know.
Right.
It's cited at the end where the legal references are.
Yes.
Yeah, and that, right there in section 4, in that same section, that points to the
Oh,
federal
right.
code.
No, I see. Yeah. Okay.
And Neil, as I read it, it says this definition includes an individual in the same sex or common law marriage if that's recognized in the state. Is that right?
Only common law is
Common law,
recognized.
Yeah.
not a common law state,
Okay.
but yeah.
Are we not?
Yes, that's
we all
correct.
tell the
If it's
lawyer.
recognized by the state.
Okay.
So again, you have to have the
North Carolina's not a common law.
marriage
state.
recognized by the state.
I know.
That's the answer. Thank you.
Well, since Obergefell, for many places, there is no longer a legal definition of domestic partner. There used to be, including in the state of North Carolina, for some companies and insurance companies to provide health benefits to domestic partners, and you had to show proof. There was a sort of a way to show proof of that without a marriage certificate. But since Obergefell and the legalization of gay marriage in all 50 states, that now has tended to, even with our own health insurance, fall back to spouse marriage, legal marriage, rather than any other domestic partnership designation.
Thank you, Dr. Green.
And this is DPI's definition as well. One of the things you did mention was kind of citing to it, and what I realize is because it just hit me, we have in our other policies cited to the specific DPI manual section for our different portions. We didn't hear, I think because it came from the School Boards Association, and it wasn't something that we were creating ourselves. But we can, if with the board's permission, go back in and add in those DPI sections, which will at least help point people to where like that definition section comes from within this policy.
I think that's really helpful.
Okay.
And I think we can, if we decide to move forward with first reading, I'm comfortable if other folks are, just assuming that it's going to be there when we see it and simply.
Okay.
Dr. Ng?
Yeah, I got a language issue question on D1. And I heard you say it differently, which kind of prompted me to think about this, because it says here, the 12-month period for purposes of calculating an eligible employee's 12-week FMLA leave entitlement is measured forward from the first date of the FMLA qualifying leave when the employee otherwise would have been expected to report to work. And I remember heard you saying event.
Yeah, I said qualifying leave event, but yeah, qualifying leave. So that would be when you went out, when your FMLA event happened, or your qualifying event happened, that would be the start of your 12-month.
Yeah, because I was just thinking, because a lot of times people are submitting these, and then trying to retro to the start date of that event that prompted the leave.
Yeah.
So
If you have a family member that's in the hospital, you don't expect it to go a 12-week period.
Right. So I wonder if it's clearer to say event and or is that going to muddy the issue?
And we call it in section C, we call them qualifying conditions. So we could call it a qualifying condition, if that helps. That's where you begin running whenever that qualifying condition occurs. When the adoption happens, when the birth happens, when the serious health condition happens.
I just, because you're using the leave in a different way.
Okay, sure, we can make that change.
Yeah, I didn't follow that.
On section D, number 1, the third line,
when it's approved, the other one says
from the
kind of
first
says
date of the
when it happens. So
FMLA
that's not your start
qualifying
date.
leave versus the condition. Although I guess, the employee really would determine when they wanted to start the leave. So that's the difference. I could have someone with a serious health condition or my own serious health condition, but I'm not asking for the leave until a week later or 2 weeks later. So I'll take that back and say it's probably better to use it for the leave.
Are all of these one-on-one conversations with a supervisor, or do they all come through your office?
They actually come through another section of HR.
Okay.
So the talent acquisition section has leave processors. The HR leaves team is what they're called. And they receive that. The employee will submit the leave form at the school level, but the FMLA documentation and all of that flows to HR leaves, and they're the ones who gather all the information from the employees.
So,
I can see your point, and a lot of times when I'm filling out these forms, is basically I ask a family member or whoever, it's like, what day do you want me to start this?
Right.
Yeah.
Exactly.
moving on to E.
Moving on, thank you. So section E just talks about some of the situations where leave is entitled. It includes service member leaves as well. It talks about some of the restrictions regarding spouses employed by the school system. Section F gives more details about military service exigencies, since that is built into the FMLA to allow for exigencies for military when someone is deployed and those sorts of events. Section G goes through the intermittent and reduced work schedule. And again, these are things that our HR leaves team are dealing with on an ongoing basis every single day. We just added in here a clarification, and here and in section F, superintendent or designee, just to make it clear. Section H talks about some of the restrictions regarding instructional personnel. There are restrictions in the federal regulations about instructional personnel taking intermittent or reduced schedule leave. They build in some language so that it's not disruptive to the school environment. So there's some limitations about intermittent leave and how that can be taken. There's also in section H2, information for instructional personnel, where the school system may decide to extend somebody's FMLA leave so that it doesn't disrupt. For example, if you have a teacher that's been out for, the whole year or a good chunk of time, and they are ready to come back, it's near the end of the school year, we may ask to extend that leave so that it's not a disruption to the employee, to the school environment. But we also added at the end of that section to make it clear that if that happens, those absences aren't going to be considered excessive absences against that employee, because it's something that the school system is doing there. And you'll see throughout the policy where it talked about term and we changed it to semester, just being consistent with our language. In section I, this lays out for employees what their responsibilities are with regard to leave. Section 1 talks about when leave is foreseeable, and we've added in here some of the examples from the regulation about what are foreseeable type of leave events. And then section 2, when leave is not foreseeable, again, we've added some information in here about what those sorts of events may be, and what the employee's obligation would be with regard to that. Section J talks about our responsibility in designating FMLA leave and notifying an employee when their leave is designated for FMLA and us complying with those requirements. Section K talks about certification and the ability of the school system to require certification for leave, as well as asking for additional information if the certification is not complete, as well as asking for periodic recertification if need be. The green language in here just shows that we moved it from one place to another in the policy. Section L talks about an employee returning to work from leave. Section M is substitution of paid leave, just making it clear that employees have the opportunity, because FMLA leave is unpaid, employees have the opportunity to run paid leave concurrently with that non-paid leave. So that just clarifies that section. It also makes it clear that if an employee, a non-exempt employee, non-exempt from the Fair Labor Standards Act, has accrued comp leave that they've used, that they have to use that first before substituting other types of leave. Section N, restoring to equivalent position, and just makes it clear in terms of our duty to restore an employee to an equivalent position. We added just some language in here, making it clear it doesn't have to be the same position at the same work site, but also making it clear that we will look at job descriptions and practices when putting someone in an equivalent position. And the superintendent or designee has a right to assign personnel consistent with board policies. But we have to, we can't reinstate somebody to a position that requires more licensure than what that person had. We talk in section O about continuing health benefits and making it clear that an employee is responsible for any premiums and benefits that they have that are normally deducted from their paycheck, and making whatever arrangements through comp services to deal with any sorts of deductions if they're in a non-paid status, for example. And the rest of this is just consistent with section P, is posting and record-keeping requirements, enforcement, and making it clear that if someone seems to be engaged in fraudulent activities during FMLA time, that the school system can deny FMLA benefits in those occasions. That's FMLA.
Very thorough, and I appreciate all of the additional definitions, and also anticipate the same number of questions to someone else's office within HR, just because of the complicated nature, because it's usually happening during a strenuous time in a person's life that they're having to access this.
Absolutely.
Are there any further questions? Dr. Ng?
I just want to clarify, when you say equivalent job, I would assume that it's the same pay.
Mm-hmm. Yes.
Okay.
The equivalent position has to have virtually identical pay, benefits, working conditions, privileges, all those things. That's the second paragraph under there. Yes, we can't. One of the things that our office talks about that we do deal with in employee relations is making it clear that We can't discriminate against people because they're taking FMLA. We can't retaliate against people because they're taking FMLA. We can't mistreat people because they're taking FMLA. This is their right, and we're going to work to protect that right.
Do we have a motion to go to first reading?
So moved.
Second.
All right, a motion by Ms. Caulfield, a second by Chair Haggerty. All in favor, please say aye.
Aye.
And we'll move on to military leave, 7530.
And once adopted, the FMLA will replace Section 8.2 of Policy 3800. And then military leave, a much shorter policy than FMLA, but equally important. This policy deals with military leave based upon state board policy, USERA, which is the Uniformed Services Employment and Reemployment Rights Act, as well as our general statutes. This is another policy that is from the North Carolina School Boards Association Policy Manual, and we've added just a couple of modifications here. In Section A for notice and documentation, we made it clear that it would be provided to the superintendent or designee. In Section 2, we changed this to reflect, to be consistent with some of the language in the DPI manual, making it clear that employees have to provide a copy of their orders or other appropriate documentation of required military duty. The sample policy said for leave periods exceeding 30 days, but we require it for any military leave, so we kept that in that policy, and again, consistent with the DPI manual. For short-term military leave with pay, these are just some minor changes that we made with regard to the language there for employees who are reserve employees who are taking leave there. And then Section C deals with unpaid military leave for extended activity duties. And we just clarified in Section 2 here that when we are paying for the difference between military pay and work pay, that an employee has to provide a voucher or some other sort of information so we can determine what the difference is between military and school system pay. Section D deals with reinstatement from military leave for our employees. And E talks about making sure that employees are provided with information about their rights and benefits under the military leave. And F just says we're going to comply with all laws and requirements related to military leave.
Are there any questions?
And this would replace sections 10.1 and 10.2 in the current manual.
So, any questions on this? It seems pretty straightforward from federal policy, from DPI policy. Mr. Hershey?
I was going to say a motion to move to first reading.
Second. All right. We have a motion from Mr. Hershey, a second from Ms. Edmonds. All in favor, please say aye.
Aye.
Ms. Hill?
And would the board be okay with us adding the DPI sections in this policy as well?
I believe so.
Okay.
I'm not hearing any.
Can we just make that kind of standard if they, so they don't
I
have to
think
ask
when it
every time?
comes to leave, I don't know that we have any other leave policies, but just, we'll assume going forward that
Oh, we
that
do
is
have
the yes.
some.
Well, then let's just assume that that's the,
Okay. We
The
sometimes
standard.
forget when we're not creating the policy ourselves, but we will make sure to.
as long as we get it there by first reading, we'll be okay.
Absolutely. Thank you.
Yeah. All right, so we have a motion and a second on the table to approve 7530 military leave for first reading. All in favor, please say aye.
Aye.
If I already did that, I apologize. Any opposed, nay? Okay, thank you.
Thank you all.
So we are going to move on to a discussion framework regarding policy 1710, 4021, 73, 7230, prohibition against discrimination, harassment, and bullying. With the work of, the help of Dr. Robinson and his policy team, and Dr. Crane, we kind of wanted to talk about what folks would like to see in this policy, and so I figured a good way is for each individual board member to capture their changes. Oh, thank you, Dr. Crane. And so we have this beautiful sheet of paper coming your way. I will point out that I did not design anything this nice looking. But what do you within the policy, so taking some time, and I'm thinking about 7 minutes to notate what you find valuable within the policy, what needs more explanation, what would enhance the effectiveness of this policy, and then what would you re-examine? And so rather than have, the whole policy read out, I know we've all taken the time to look at this individually over the last couple of years. If different things have come up, so I figured we can jump right into it rather than me reading from a page, if that's okay. And I'll set a timer for 7 minutes, and then we'll come back to it. And then, once that 7 minutes is over, we'll find a partner, share, see where the commonalities are, where the questions are, and then we'll come back together as a whole group. All right? So it's going to be a little quiet, or it doesn't have to be quiet, but I think that's a way to have this and to find what those common threads are with this. So appreciate you all. Well, the agenda says 45 minutes. I'm not going to keep you past, so it is 4:29, just so we have the time check. And by past 5 o'clock. I've got 1 minute left on my timer. That doesn't stop you from writing during the next part. It's not an EOG. Yeah. Flip your Scantron over. Oh, no, wait, there's no Scantron anymore. Okay. So before we get to the next part, I realized one of the things that helps with this policy is there's quite a few legal definitions here when it comes to what bullying is. So Neil, when we're done, I'm going to put you on, not on the spot right
Sure.
now, but, or right now if you want to roll with what is, well, let's get to the questions first. So if you want to find a partner, I'll just have you, I mean, I think it works out, Cheryl and Wing, Chris and Toshiba, and then I'll put Milan and Sam together since we're down here. Just kind of share in your pair or small group, like, what are you doing, and let's see where any commonalities are. And I know that wasn't a lot of time, but again, this was one of the first things that many of you voted on when you came on the board in January, so, of 2023. So, but I appreciate you all being willing to look at this again. So we'll do 5 minutes for this part. Does that work? And then we'll come back all together, and I'll then put Neil on the spot. If I don't have a timer, it'll be like 10 minutes. So.
We got lots of stuff.
Yeah, we're kind of on the same page, definitely.
Yeah.
Okay.
Just thank you for that.
They're going to collect us too. Here.
Differentiating
This might be a to be continued.
Yeah.
I mean,
I didn't
Yeah.
pick out
however
anything.
long, because
But I mean,
Anything which is available.
No.
I think the whole policy is extremely
I like that it clearly defines.
So I had a question about that.
Yeah.
Because I don't see in section B, application of policy, where it lays out, where this policy applies to the behavior that takes place, blah, blah, blah. I don't see how this,
It's hard for me sometimes to figure out
works with the cyber.
I was put something in when really.
But I think that's a great question.
People are talking about it a lot, but not that specific.
So I think it needs to be more clear, but,
Yes.
So what I took is just a general concern.
Facebook groups or whatever, TikToks about rating kids, ugly kids.
She wanted some words.
Anyway, that can also happen like anytime, and certainly off campus. So I just think it has to be more clear.
Okay, the principal slips some comments, talk to each other.
Yeah, actually.
See, this is why.
I know, but what's going on for the student that's going.
I know.
The agreement was.
Words are reporting volunteers and violates of policy and slash law enforcement as appropriate. That's one big change. In accordance with the visitors to school policy. Would that be an automatic report?
And Lynn's, because it was during Lindsay's tenure during her time.
And that might be in the policy. That's great. Clarifying question. Right. And I put in section C, who are employees required to report to their supervisor question marks, because it links to the policy directive is, but it doesn't.
I have a tweak in section A, number 5. I think the gender-based language needs to include the terms gender identity or gender expression.
Case law, to some extent, we're definitions, but I don't think
Gender-based harassment, or prohibits unlawful gender-based harassment.
there's more straightforward application. In particular, I thought about 7 harassment.
Oh, yeah.
The gender identity or gender expression
OCR attorneys,
needs to be added.
Yeah.
their perspective, they're very different.
Isn't that up in the?
It's up in the top.
It's up in the top, but I
Yeah,
think we
it's
need
just
to.
not, no, I get, right.
Bullying, that's just picking on kids.
Are you, can we do all of ours
Yeah,
together?
yeah, go for it. What else you got?
So you said that
No, I mean, are you gonna capture the ones in the paper and turn in one?
No, we're gonna hand in all of them.
All right,
So we're
okay.
gonna present what we have together.
So the cyberbullying, since it's defined, we just say we need to
Both prohibited in the policy
in the enforcement,
just so that people
the
understand.
application of the policy needs
Right,
to say.
that's not
it's-
specifically addressed.
Yeah, I agree.
Both harassment investigations, which are warranted if it's official harassment, but not if it's like.
But the question then becomes,
Lunch and has nothing to do with race. I think that can be quickly.
Say that part line.
Reporting department time, just a thought.
doing my work is
Very good process.
anywhere.
Well,
So
like in the neighborhood.
neighborhood, they had right under,
grievances. We have to differentiate what is the difference between the two. But if it was separate, we can say no.
that would be,
That's a great thing to have.
Or this based upon this definition. So I think it's
You
really.
wanna write it on mine?
you have
That's
much
done.
nicer. No, but so like,
But I think providing them the information and giving them coming into the school.
We have to take a look at it. We're talking about doing our research and come back to you with,
Absolutely.
how would that be different, hopefully, but it might be worth looking at, because otherwise we have emerging two concepts, by the state umbrella school.
but just in the neighborhood.
Right, or they're in Boy Scout troop together or
That's,
whatever.
I classify all that as
Yeah.
not in school.
Right.
And, what is,
So would that be under the tweets, maybe?
well, I don't know if we're allowed 10 days of that. I don't know, how does,
Yeah, and that's why I should have led with Neil first off, but we were already here.
no, I think it's good.
But it also gets out.
Yeah, but Title IX, it's sexual harassment, Title VI,
Those are two that we hear about.
Yeah, Title VI is the discrimination, racial discrimination, and things like that. Title IX is
They could be walking, they could be walking technically.
But so there's a longer
Say at any bus stop.
you know.
I got 1 minute.
Subsection like
Sorry.
something that.
No, it's good.
So, and then I think
Legally protected.
consider part, what would you read?
But again, folks, you know, I expect a lot of full building harassment investigations, lots of times, something like probably they could do a little bit more.
When do we see the evaluation of the efforts? Does that set the very end?
I'll see where they lead us on, you know, make my own
Meaning like the prevention.
It says the superintendent evaluation.
Yeah.
Is that I or I?
Yeah.
Shall evaluate the effectiveness and share these evaluations periodically with the board. Have we had one? I mean, maybe we have. I mean, we get so much stuff.
Not since we've been on the board, I don't think. I think we may have talked about it.
That's right. So to me, I would rather have like an annual
Yeah.
evaluation.
All right.
That way, not just for us, but for the public to hear that we're talking about it.
I'm just going to pause the conversation because I think we're going to continue this as a whole group. But before we get to that part, I'm going to quick hand it over to Neil to talk about, because one of the things when we last looked at this, and I know this last came through policy committee in 2022, around or right before the election. So many of you were not yet on the board and necessarily able to give input. And I know giving input when you're fresh on the board is not always the same. But one of the things is the legal definitions that we're looking at. And so I'm going to ask Neil to kind of go over what is all this stuff in the back that takes up nearly a full page.
So the definition, on section A, the prohibited behaviors where it
Right,
defines
right.
discrimination and bullying and harassing behavior.
What is hugging statute? What's hugging? I mean, I know there's a huge section on Title IX and
Yep.
sexual harassment, so.
Yeah, it's a good question, and I can't really thoroughly answer it without going back to it. I do know the origin of this policy, NCSBA drafted it, and I know for a fact they pulled for the case law in the definitions, especially for harassment, because I recognize some of the case law language that pops up a lot. I will say, I do think, just having a sidebar with staff on this, I do think it probably could be written a little more clearly for people who aren't lawyers, who haven't read case law. It's challenging because, you know, you do want to track legal definitions, and there's a lot of judge-made standards and definitions that come into what is, you know, harassment, as opposed to just picking on someone or being mean. That doesn't quite rise to the level of harassment. But I couldn't tell you, you know, what percentage of this, without going back and doing some research, comes from you know, legal standards, and how much is just NCSBA's efforts to define it. But I tend to think there could be some simplifying of the language. One thing that has always kind of troubled me a little is a somewhat circular definition of hostile environment. You see, it says hostile environment is conduct means the victim subjectively reviews the conduct as harassing and bullying, and a reasonable person would agree it's harassing and bullying, and it just takes you back to the bullying and harassment standard. So possibly we could clarify a large section of this does come out of case law, but I think maybe we could do a better job presenting.
All right. So let's open it up if anybody wants to share. I'm not going to prohibit, you know, individuals from not sharing their own, because I think this can get personal for a lot of people. And so, Ms. Caulfield, let's kick it off with you. If you want to share for you and Dr. Ng, or?
Are we just going through one at a time, or?
Let's go, I mean, let's start with the appreciates, and then I think that's a great way to start, and just keep going round robin for that.
Okay.
And then staff's going to take notes. They're going to take what we've captured, and then Neil's here also to answer any question that's in legalese for us.
So I do feel that it is quite detailed, the policy, and there is a lot of language that gives, I just went off of everything, but there is a lot of language that comes that is listed in what we reference. That's one of the valuable things that we found. We just have something else.
Yeah, I mean, it seems very comprehensive, but I think that was the point of kind of the legalese, that it was kind of meant to to follow some of those legal decisions. So I appreciate that. You know, it kind of spells out some of the various different definitions.
Nothing. Nothing
Lynn?
that hasn't been said.
It's a great starting point.
Yeah, I think when we talk about it, the definitions were very helpful. They're very thorough, included a wide range of different actions.
So let's go on to the clarify piece, and I'm just going to go back to you, Cheryl. And I think this is based on some of it, we may need more clarification on some things, but go ahead.
Right. So as far as it says what would enhance effectiveness, is that what we're working on?
Yeah, the blue one.
The blue one.
Oh, okay. So I think, and I'm not really sure if this is really so much policy, I feel that it would be helpful if it was policy, is in our policy being clear and consistent as far as consequences, what each one means, also our levels. If we could maybe bring that to the table. It's not really answering your question, but it was some of the things I was reflecting on is, with some of the conversations that we've had with, like, teachers and coaches and stuff talking about this stuff, you have levels that 1 through 5, and that determines like the consequences and where we kind of lean each incident towards. But some of the circumstances, I mean, if you bring a weapon to school in your backpack, it's not necessarily something that is you're doing to somebody else that would fit into this policy, but the level of that severity versus, say, we saw an incident where somebody hit a teacher. We know that happens with kids in the classroom and also in the hallways and on the fields. So
is it like in reference to bullying under the consequence section, like showing specifically or linking
Right.
to
or
the code
revisiting
of
what our
conduct?
levels look like and
Yeah.
if they're really in the appropriate areas.
So and that's a different policy, right? So, I mean, looking at the code of conduct at another time, because I'm trying to keep it focused on bullying, but I'm hearing what you're saying, like where's the link between bullying and the consequence piece in regards to what our code of conduct and what is the expectation?
And how it links it together,
Mhm.
basically.
Yeah.
Because we can have a beautiful piece of paper that explains everything under the sun, but
I mean, we really can. Yeah.
to link it so that it all the pegs fall in place. So that was-
My clarifying question was about cyberbullying, and I heard you kind of mention that
Yeah.
too. But it's just because cyberbullying can happen outside of the school, but it has impact inside the school perhaps. And so, what are our responsibilities? What is enforceable? What is not enforceable? Those are the things I have a question on.
Yeah, and I think Lynn brought it up, and Sam and I agreed. We defined cyberbullying in Section A, but in Section B, it isn't specifically addressed. Maybe it's housed under B6, anytime or place when the behavior has a direct and immediate effect on maintaining order and discipline in the schools. But I think that was the clarification piece. Does that link up? Or can we specifically address it?
Right, maybe we
Yeah.
need to be more clear about it.
It did not link for me. I mean, I agree with you. So, because, obviously, kids can cyberbully off campus, away from a bus stop, in their own home, but it certainly has a direct impact. So I just think that it's not clear the way it's written now, and I think it.
And that led to a broad, go ahead.
Well, I was just going to note that this is a particularly challenging legal area right now because the U.S. Supreme Court has done us all the favor of overturning the rules that we used to think applied to student cyber speech, not replacing them with any new rule. That was the Mahanoy case from a couple of years ago. So we now have like one paradigm example that came to the Supreme Court of a school overstepping its authority to suspend that cheerleader for her, social media posts on the weekend at the Cocoa Hut or wherever it was. But we don't have a rule. And so that makes it a very challenging area to legislate. And we can certainly give thought to it and come back to you with some other thoughts.
Well, that's helpful.
Suggestions.
I mean, the fact that you're letting us know that, that is helpful that we're somewhat stuck. That's the
why we're
answer,
saying,
right?
what can we enforce?
Yeah,
Right.
It's challenging. It's very challenging right now. We don't have a rule. It's going to be years, would be my guess, before cases emerge and we have appellate precedent we can rely on. There's one Fourth Circuit case that I tend to think is still good law here, the Kowalski case, that relates to targeted defamatory harassment of a student by other students online. It was very egregious facts. I think we can make an argument that's still good law and rely on that. But when you step beyond that, it becomes more questionable about when a school administrator can step in for student cyber speech if it's not during school hours and not at school.
So that led to a conversation because let me rephrase, I certainly have heard from parents that talk about bullying that happens, not cyberbullying, but just straight bullying in wherever their community is. And so what exactly would be the difference between that and cyberbullying? I don't know if there's state law, but we don't really address that, but we hear about it quite a bit. That something has occurred prior to coming to the bus stop.
So, Neil, could you kind of share with the board what we would call the nexus of if something happens outside that leads to an event in the school and you can discipline a child with a code of conduct, but how that might differ from cyberbullying, which in essence is almost the same thing if there's a nexus, but the Supreme Court ruling may have taken some authority. So kind of juxtapose that for me.
Yeah, that's the great framing of it. Yes, there's the nexus language, as we call it, is already in your policy, which is, this is state law, that schools generally have authority to discipline students for off-campus misconduct. I'm not talking about speech here, but their conduct, beating another student up, stealing some money from someone, if the misconduct has a direct and immediate impact on safety and order at the school. And that's a standard that's been around a long time, so we have some familiarity with how to apply that in individual cases. Where it gets tricky is when we're talking about speech. So if a student is it's social media commentary or whatever, then they have First Amendment rights, and the Supreme Court, again, hasn't told us where to draw the line. And in fact, they've erased a line that we used to have in the Fourth Circuit or from other cases. So I think to Dr. Taylor's point, conduct that doesn't involve exercise of First Amendment rights, we apply that nexus standard. Is there a direct and immediate impact on safety and order at the school? Usually principals can tell me very quickly if the case is going to spill over into school. We can make that argument. But for speech, it's just trickier.
But that's not in this policy. That's in the Code of Conduct.
I think there might be something in.
No,
it is in the Code of Conduct.
It is a more complicated legal issue.
Yeah,
I know,
I mean-
and we can talk about, and there's been some student or some school board association stuff on it. I'm happy to share, Neil can. I just want to get through some.
And we're definitely going to be moving this and continuing this discussion because it is 4:56. So don't think that this is the end of it. We may not see it in May, but that doesn't minimize the importance of this because it is really important.
Ellen, did you have anything?
I did something about Cheryl said, talking about the discipline policies, the code of conduct, and how that fits here. I had the same note that in Section D, rather than list the consequences in this policy, link to them in this section. And then if we can still, I don't disagree with revisiting code of conduct, but not to list all that here because I think it's better to link to the code of conduct. That's just my opinion.
And so just building on that same thing, I had the same concerns about like that direct and immediate effect on maintaining order for the cyberbullying, and that's just going to be a bigger conversation. For me, the areas that need more clarification, understanding what we say about the code of conduct and that there are specific things that could fall under the code of conduct, I just think it's really frustrating for parents and for others when they see this, that we talk about, well, we'll take prompt appropriate action, but that just seems broad and undefined. And what does that even mean? What are the consequences? And like, do we even need a section on here that could save us all a lot of misunderstanding about what are not appropriate consequences? You know, how we're here, well, is transferring a student away, that's not a discipline, right? But you hear people ask for that, or that we can't explain, that we can't notify parents that we're disciplining some other student. Things like that are just like so frequently asked. I wonder if there's a way we could include that in the clarify section. Just because it'll be the last thing for the that I'll probably get out, the considering, one thing to examine. I'd love it if we could have something about what are parents' roles and responsibilities, because I think a real challenge is, what do we do when parents enable this behavior? When a school calls a parent about a situation with bullying, and then the families of the parents don't take action or are combative, and then the behavior consists, and for enhancing effectiveness, I'd like to see if there was some sort of assessment or evaluation for the bullied student. I mean, how do we know what they're going through and what they might actually need? How do we create awareness with parents? This is something I got from Toshiba about how they understand inappropriate behaviors, expectations, and concern. And then, again, to Cheryl's idea just about those consequences, getting more clarity.
I hear Dr. West in my head going, hurt people, hurt people. Ms. Rice, do you have anything to add?
No, just to what you said, in my professional world, I've changed that language. Hurt people don't hurt people, because I can hurt your feelings really quick and Chris, you'll be fine. At this point of where we're in with this bullying, hurt people are harming people. And when you use that language, that it's not hurt, it's a harm that's actually happening right now, because it trickles down and it continues into their adult lives. And we're seeing children not healing from the hurt and not using appropriate consequences. Appropriate consequences at a root cause is behavioralism. It's changing the behavior of the student versus a consequent of punishment around removing you. There needs to be a rehabilitation process of that learned or thought behavior within the person so that it doesn't continue over into the adult life. And so that's my perspective around that, is tweaking the effectiveness of a consequence that deals with changing behavior, because behavior changes is what makes our society a bit better. And we want students to heal, like you said, so that they are not playing out what we're seeing in schools of returning back because you're still hurt and no one never did any effectiveness with healing you and validating you because you were harmed, not hurt.
I like that. My one is just the continued clarification of Section A, number 2, what justifies a pattern? And I think that's always a hard thing to define, because, if I don't have if it happens 1 time, 2 times, 3 times, well, all of a sudden it happens 4 times, a kid is fed up. And those first 3 times weren't documented because it was one thing, and so I don't know what the answer is. I know it used to say persistent pattern. Any pattern is what we, switch to, and I think that's still a hard thing as we're looking to define it, and that's always a question that comes up. Cheryl?
So I appreciate that we're bringing the bullying here and talking about the policy on bullying and disciplining is a big thing. So I appreciate it coming here. I'm just wondering how we can bring the pieces together. The policy itself is very, has a lot of description in it. But I'm not sure how that really, how it attacks our effectiveness, right? So we have lists of harassment and bullying, and we have language around the harassment, but not really defining what that means, and so that people understand what we're trying to get at. They could read the language and see the definitions, but like what you were just saying, I mean, the difference between bullying and harassment doesn't necessarily mean to be a repeated pattern. And it doesn't necessarily mean that somebody is physically pushing and attacking somebody. It could be a one-time event that that person is just not stopping, and that you're being led into an extremely uncomfortable position. And then, you know, on the flip side, it doesn't really talk about the bullied person. It doesn't talk about and redirect. If I was a parent and I looked up our bullying policy, I already know what bullying means. It might be a thought of mine. I'm not saying I don't need the policy.
Right.
But where do I go from there? And yes, I know we have the code of conduct, but I feel like there's not enough language.
How do you help your kid when something happens to your
Exactly.
kid?
Like, where do I go from here as a parent? What do I do? Is this what the school is going to help me with, and who do I go to? So having links like that in our policy that get us to the right places, and then us coming back to the table to have that language and discuss it and talk about it, because I really feel like, you know, either whether it's videos, this is what it means, examples, you know, to show to our students, you know, like, no, what you would, and then a kid could actually realize, oh, wow, I actually do that sometimes, or, you know, they didn't really consider it to be bullying, I was just kind of joking around, but maybe it gives them a second look to think, maybe I should second guess before I do something like that again, but.
We used to talk about intent versus impact a lot when I was
Yeah.
teaching.
Exactly, yeah.
Neil, and then it is 5:04, so.
I just wanted to very briefly, to the question, note that Policy 1720 is sort of a companion policy to this that does provide specific avenues for parents to file formal complaints of bullying or harassment, sexual harassment, cyberbullying, all of these things. Get written reports, it's appealable, they can ultimately come to the board on appeal. So in addition to the consequence section here, which references possible disciplinary consequences to employees and students, you also have parent and student rights to get a response and corrective actions.
And, you know, also understanding that as a parent, filling out that grievance should be like a last resort. You should be able to work with the school in order to get some understanding.
I'd love for us to have more discussion on that part, because sometimes that is our difficulty, or the things that are coming to us is they're following a procedure, but everything else is so subjective that they might not be reaching a solution. So I think that's a big conversation.
And going with Cheryl, there's things are micro.
One more thing?
Yeah.
All right.
So it would be super helpful to get an evaluation, which is I.
Section I.
Yeah, evaluate the effectiveness and then share it with the board. I think that would be helpful so we have understanding of what's going on.
And we haven't seen that since we approved
Yeah.
the new policy that we're looking at in 2023.
That's it.
And with Cheryl was talking about examples, I know there's examples in here, and one of the paragraph, I think it's paragraph 2, under harassment and bullying include but are not limited to. But a thing to add for them to consider is these microaggressions, and this is coming from a place of looking at being equitable in behaviors, which sometimes can instigate the other behaviors that we're seeing around bullying and harassing.
Close that one.
Something really quick, I found it very useful. My daughter in swimming, you know, they required us to go through that safe sport training, the U.S. Center for Safe Sport, and they do a lot of talk about, you know, the bullying and the sexual harassment and things like that, and in a way that's kind of visual and digestible, you know, and so, you know, something to think about in terms of how to have that discussion with our youth.
It's not the 1980s after-school special.
I was thinking of that.
Yeah.
I was going to date myself, but I didn't want to do that.
I'm with you. So we're going to continue this conversation. I appreciate you all taking the time and your thoughtfulness and thoroughness on this, because it's something that is very important to our students and to our families, our administrators, and our staff, that we need to have clarity around this. So Dr. Robinson, what do you need?
Yes, if I can have an axe, please. I would like for everybody to take their paper, and if you would kindly fold it, I believe that's...
Stand-in usage.
I'm taking it out. And what we'll do is we'll collect this and we'll capture all the information, but more importantly, as we continue to engage in the conversation, we'll make sure that you get your form back, so you'll have everything that you captured. So
write your name.
Yes, please write your name on the back of it as you fold it, in the top right-hand corner on the left.
Oh, no.
I'm just kidding.
Would you like me to underline it in red or green?
No, I'm just kidding. That way, we'll make sure that you get your forms back.
Yeah. But thank you all. This is not the last time that we're seeing it. Again, in May, we're going to bring back the Crown Act work that we did, and we're going to talk about sustainability. And it is 5:07, and we'll call this meeting adjourned. Yes, Dr. White?
Before we adjourn, I would like to note today is April 23rd, which is worldwide recognized as Shakespeare's birthday, and in a much broader sense, a World Book Day. So I hope you get some time with your favorite book or author. And in a nod to the bard, I'll say good night. Parting is such sweet sorrow that we shall say good night till it be next Tuesday when we see you again. Till it be
The
mine.
teacher out of the English class, but you can't take the English class out of the teacher. Thank you very much. Have a good night, everyone. We are adjourned.